Get me out this
Sir,
room, man.
sir,
You almost killed me, man.
sir,
I can't
sir.
keep going through this, man.
sir.
I'm not gonna go
Sir.
through no evaluation because I got an education, man. I'm not going through that no more.
Sir.
You did this last time to me, man. It's already a conflict of interest.
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right, and you understand for my purposes, though that language doesn't make any sense. So
No, I do not.
I hereby declare that I am a living, breathing human being, a natural person distinct from any legal or corporate entity or fiction. I do not consent to be represented or binded by any assumed legal identity or straw man.
I'm going to order a competency evaluation, parental
I'm gonna order you
evaluation.
for a competency evaluation, man. Crazy, man. I'm finna sue y'all, man.
You want to
I
know
leave
what?
here.
You keep talking, we're going to have a problem.
I am inclined to believe that you are both the agent and the person, so. And it's in
I'm
all
not a
caps,
person.
by the
I am
way.
one of the people. Thank you. I haven't been
waiting.
Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
Okay,
Hey, you finished? All right, the court on its own motion is going to adjourn this because we're going to have an issue here.
but I just want to make sure, so you still wish to represent yourself?
Absolutely.
Ms. Squally, your name, please.
I am not. Forgive me. One moment. My name is what you asked
Yes.
for?
I did.
No, I'm not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern or is this a,
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports. He was
Who is
just-
him?
don't interrupt. I'm letting
I read
Ms.
him-
Langley
I
go.
read
Now,
him-
you just sit quietly.
Thank
I
you.
read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
All right, and as the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as
Okay.
written in all capital letters.
All right, and you understand for my purposes, though that language doesn't make any sense. So
No, I do not.
I understand. Okay, well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person, so. And it's in
I'm
all
not a
caps,
person.
by the
I am
way.
one of the people. Thank you.
Okay, thank you. All right, so for the record, that's my finding. Yeah, hold on, we're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony, probable cause application will be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She writes that on March 31st this year at approximately 13:53 hours, she responded to an unwanted person complaint at a 7-Eleven store located at 2425 Marvin Road Northeast in Lacey. Dispatch advised a male was refusing to leave the store and was being disorderly, yelling at staff. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5" with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. They advised that at one point the male stated he would be waiting outside when they got off work. The staff advised that they asked the male to leave multiple times and he refused. They also advised that once they called the police, the male returned to his Toyota 4Runner, and the license plate is provided here, and then that it was parked outside the gas station. Staff provided a prepaid phone and a charger that the male had left on the floor inside. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male, immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held accountable. Officer advised Mr. Milton that he'd be trespassed from the 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" Officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Peyton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. Excuse me, the Nisqually jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction or
Yes,
on the
Your
assault case?
Based on the new law violation, yes.
Thank you. And let's see.
Will I get a moment here to articulate anything?
I'll let you know. So sit
Appreciate
tight.
it.
I'm still working through the process. Thank
Of
you.
course.
All right. So, Ms. Sharp, it appears that the assault was not a deferral. It was a stipulated order of continuance.
That's correct, Your Honor.
All right. Thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Ms. Langley was counsel of record on that case. Well, I will, and Mr. Milton is asking not to be represented by counsel. Is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice, but I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information, actually.
Okay. So not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do. You will do things you're not supposed to do. And all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them, I think it's a foolish decision to make. You, however, have that right, as I pointed out, but I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
This is where sovereign citizen thinking quietly collapses. The belief in a separate legal identity feels empowering because it gives control. But in a courtroom, confidence doesn't replace procedure. By rejecting counsel, he's choosing a path where every mistake compounds and the system won't slow down to correct him.
And how do you choose to go forward?
Pro se, please.
Okay, you even know the right term, okay? All right, I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke these continuance and get a conviction on the assault charge. So that's at risk here with this new allegation. So I want you to be aware of that.
Appreciate you.
And Mr. Sharp, city's position on release.
Thank you, Your Honor. I'd point out that we just resolved that other case on the 22nd of March. That was done in custody. $1,000 was the hold at that time. The city's argument for that bail was based on the nature of that case being an assault, as well as, and I think most importantly, the outstanding warrant out of Skagit Superior Court. That warrant is still active. We're here with, even more concerning circumstances now with another charge. City's request is $500 bail on each case for a total of $1,000. Law-abiding behavior, no contact with the 7-Eleven on Marvin Road, and no consumption of alcohol, marijuana, or non-prescribed drugs, nor frequenting of bars or taverns, as alcohol does appear to have been a factor in this newest case.
Thank you. And has anybody checked to see if Skagit County has been contacted regarding executing on their warrant?
I don't have any information either way on that, Your Honor.
Okay.
I believe that when, he told me,
Excuse me.
I was.
Please
Never mind.
don't allow her to speak in my stead. Thank you.
No. Okay, I'm going to ask Ms. Langley a question. Ms. Langley, what do you know about the jail's policy in that regard?
No, I only know what I learned before is that he had contacted Skagit County and they needed him to appear in person to deal with that warrant.
Okay, all right.
Your Honor, I was not read my Miranda rights this most recent time. I believe I'm supposed to request a voyeur of the body cams.
Like I said, I can't represent you. You're going to have to figure all that out yourself for purposes of today.
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights.
Did I read my form? I don't believe I was provided anything.
Okay, is there a corrections officer there?
Mr. Upton?
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it. And then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of it.
Okay, why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
Okay, I know all I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me. I have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay, thank you. All right, so with the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance. And the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was not in possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
Okay, anything else?
That's it for now.
Okay.
Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taking a statement from in both questioned cases in question.
All right, so what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
I was never aware of that.
Right, which is
Appreciate
one of the reasons. Don't want to represent yourself, but I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
Okay. All right. Seem like a sharp guy, so
Appreciate you, Your Honor.
seem dedicated to it. Okay. Based on the outstanding warrant out of Skagit County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol, marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
If the minimum that I'm allowed to throw on a bail is 300 and I have to bail out for 2 things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible this time around.
Okay. Well, you may know from your history that the bail here is usually 10% of what's ordered. So $50 on each case is what a bonding company would want from you. So just, I don't know
Cool.
whether
Well, I
that
have
changes anything.
$100. Isn't that?
Okay, all right. Thank you. I will set this for 3 weeks from today at 1:30 in the afternoon. So on Monday, the 24th of April, for what we call a pretrial, Mr. Milton. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case. Just so you know, you don't have to accept it. But they will be contacting you to give you whatever offer they have. And then you'll tell the court at that time whether you wish to accept the offer and enter whatever arrangement is made, or whether you wish to go to trial. So that'll be what we discuss on the 24th.
Awesome. In the meantime, will I be allowed 4 to 6 hours of unhindered internet access so that I can represent myself?
Yeah, I do not regulate the jail. So you're going to have to talk to the folks at the jail.
If you write it as a court order, I'm certain that they will be more likely to comply than if you don't.
All right, I'm not going to write it as a court order. Like I say, I don't mess with how the jails run their jail, but
speaking of, by the way,
Mr. Sharp has heard you, and we'll go forward
on a side note, if I may, Your Honor, during intake, and I might preface this with, I have gone to anti-kidnapping training. I was inhumanely subject to what I would define as torturous actions. It was by C.O. Patero. I have nothing against the man, but he only sought to escalate a situation physically that could have been de-escalated with a verbal warning, a verbal, hey, knock your stuff off, a verbal. And I was completely compliant physically, as you can see on camera if you look in holding C on the night that I was intaken. And when I was asked to be picked up and seated, they had refused and told me on their paper that they checked on me every 15 minutes when I was checked on about 3 times the first 2 hours and about twice in the last half an hour.
Okay.
So,
all right, we got that.
Yep, appreciate you.
Right. Thank you. And we'll see you on the 24th.
What's your name up there at the at Nisqually?
My name is Peyton Milton, Your Honor.
And Mr. DePister, you here with Mr. Milton?
No, I am, Your Honor.
Oh, I'm sorry, Ms. Langley.
Here I am.
Hey, so I was never able to review the documents that I was supposed to sign. I was also
All right,
told.
so hang on just a second. Is there a deputy there near you?
Yes.
Ms. Langley, where do we know where the document is that he?
It's in the system it's in the system somewhere, miraculously.
I'd love to read what I'm signing.
Yeah,
I-
that's,
We like
Mr.
that
Milton,
too.
that's entirely reasonable.
Yeah.
Mr.
Your Honor, I
Sharp,
can
know
help.
where it is?
Yeah, well, it just locked me out. It's in today's 1:30 pre-negotiations folder.
Okay, I see. And so is it in the defendant's folder now? So the clerk Ms. Garza just moved it into the defendant's folder. So Mr. Milton, you can go ahead and take it out to, if there's a deputy there, tell
Yeah.
him it's, can he or she come on camera?
Hello.
Hi there. So basically it's in the defendant's folder in the computer. So if he can get out there and take a look at it and sign it and then just bring him back when he's done, that's fine.
Okay.
Cool.
Take all the time you need there, Mr. Milton.
Thank you so much, Sam Meyer. Your Honor.
Hello, Mr. Milton, again.
Hey, Your Honor. It says I won't be able to enter in any evidence after I sign this, and I was never taken a statement from.
Okay, so what this is on for, and Mr. DePister, are you still there? Did we lose Mr. DePister?
Ms. Langley's case, Your Honor.
Ms. Langley, can you come on the Zoom call there, please?
I'm here.
Just give me just a second here, Mr. Milton.
Sure.
No objection if, defense needs a
Yeah,
breakout room to talk about it.
Give me just a minute there, Mr. Sharp. So, Mr. Milton,
Yeah.
you're here on a simple assault charge.
Right.
And it's scheduled for a plea of guilty. So when anybody ever
Oh.
gets charged with a crime, they have kind of one of two routes to take. They can either take it to trial or plead guilty, or the state can, or the prosecuting authority could dismiss. So I was told you want to plead guilty here today. And once you plead guilty, it's true. All the rights contained in paragraph 5 of that plea form go away.
I don't know.
Hang on, let me finish, please.
Yeah, sure.
If
Yes,
you
Your
don't want
Honor.
to do that, then you don't have to. And then we'll just set this for trial and this case will resume. So that's where we're at here. And if you want to go into a breakout room with Ms. Langley to discuss this further, you can do that if you wish.
Yeah, I just want to clarify, this would be an SOC, not a plea of guilty.
Okay. Well, that's true that thank you, Ms. Langley. If the stipulation in order of continuance is revoked, if there's any problems, then yeah, that's true. The guilt or innocence will be determined by a reading of the police report. So what's happening there is you're giving up your right to a trial, the right to present evidence, but what you're getting is the opportunity to have this thing completely dismissed. And so if you don't want, again, you don't have to do that either if you don't want to, but that's what's happening here today.
Well, Your Honor, what I'd really like is for, first off, my statement to be taken. Second off, for details that are imperative to my defense to be taken. And finally, I mean, realistically, I'd hate to be incarcerated for a crime that I didn't commit against an assailant who's known to assault people who are elderly and weaker than him. None of this appears to be making very much sense to me, and I'm sure that you can relate to why I would feel that way.
Right.
Can we have a breakout room for a few minutes?
Yeah, I'm going to send you into a breakout room with Ms. Langley for a few minutes, and then we'll come back in a minute.
I, Cartier Armani Drains, hereby declare that I am a living, breathing human being, a natural person distinct from any legal or corporate entity or fiction. I do not consent to be represented or binded by any assumed legal identity or straw man. I assert my full rights under natural law and constitutional protection as a sovereign individual. I stand before this court to represent myself. All legal matters pertaining to the charges brought against me. I reject any notion or claim that my person may be divided, operated or substituted by any separate legal entity. I affirm that all statements, evidence, and arguments I present are made on behalf of my living self, fully understanding my rights and responsibilities as a free individual.
Are you finished? All right, the court on its own motion is going to adjourn this because we're going to have an issue here. I have a feeling. I'm going to adjourn this probable cause hearing next week, August 7th, 2025. That's at 9 a.m. That is in person. He must be here so that I can hear him clearly in terms of what he wishes to say.
Yes.
Bond at this time will continue. Thank you.
Thank you. I'll follow up with you. Thank you.
Does call the case of the people versus Stephen Javon.
Hannah Mackey on behalf of Mr. Javon, who's approaching.
They did have my social security backwards and everything. Had me at the wrong birthday. I was born on Christmas, 12/25/66.
Your Honor, we're requesting to adjourn this
Can
matter.
State your name for the record, sir.
Red Crockett. I haven't had any income or nothing. They shut down. I didn't put my name at this. I didn't put my
Hang
birthday.
on a second, sir. Have you ever gone by the name of Stephen Javon?
Yeah, they had me listed at that name. That's my.
They have that listed as your name, but you're saying your name is something different now?
They had me listed at that name. I didn't know. I woke up from what they were doing to me. I had attempts to kill me, man. I hadn't had a night's sleep or nothing. Right now, my health is down, man. I'm suffering from a gunshot wound from segregation, in which I'm still going through stuff. I left a hospital with open wounds. Something happened.
Okay, but I just
Not
need
too
to
long
know.
ago. And then you were part of something. I'm really excited in conflict of interest with this. I'm really just excited to kill this case, man. Because this case is, they got me the last day of the art fair. The last day of the art fair, I'm asking you to kill the case.
What art fair?
That's what happened to me. They made a false report and they got me.
Okay, all right.
Doing this stuff, crazy
Hold on,
stuff.
hold on. At some point, I myself or some other judge will hear all of your complaints. I just need to know, do I have the person in front of me that this complaint pertains to? So that's why I'm asking you. You've been known by the name Stephen Javon before at some point, correct?
Yeah.
Okay,
Before I was.
all right. Counsel, what do you want to do on this?
Approach, please.
No.
Maybe
I
we
can't keep going
approach.
because I ain't had no income. I can't keep going that stuff with it. Just doing stuff to me out here. I've had
Is this gonna be
cases.
important? It's okay. Yeah, come on.
This is an
Okay.
open and shut state. I shouldn't be.
All right. Go ahead. Okay, what are we, record to reflect, you had a brief bench conference in this case. What are we doing with this man?
Your Honor, the people would like to request that there is an order for a competency evaluation. That is on a people's motion. I think that given what we've just heard from the defendant, it's an appropriate request at this time.
Any statement?
Valuation, and they almost killed me. Man,
Sir,
let's get me out this room, man. They
Sir,
almost killed me, man.
sir,
I can't keep
sir.
going through this, man.
sir.
I'm not gonna go
Sir.
through no evaluation because I got an education, man. I'm not going through that no more.
Sir.
You did this last time to me, man. It's already a conflict of interest. Yeah. I'm just saying.
I'm gonna say,
he got-
sir, I'm gonna say,
something now.
sir, one
I
more
had a
time.
Reaction to that.
Sir.
Almost was dead from that allergic reaction, man. You and Collins, man. Already a conflict of interest.
I'm gonna order a competency evaluation, forensic
I'm gonna order you
evaluation.
for a competency evaluation, man. I'm finna sue y'all, man.
You wanna know
Don't leave
what?
here.
You keep talking, we're gonna have a problem.
I'm
'Cause
not
I'm
gonna
gonna
get no
get through- I'm gonna
evaluation from
get
you.
through-
You're not gonna do
I'm
to
gonna
me
get
again.
through this hearing.
Yeah.
All right?
Not
If
gonna
you
be-
don't want to conduct yourself appropriately, then we'll sit you in back until you can come out and conduct yourself appropriately.
I ain't going to no competency evaluation. I don't need no competency. I had medication I shouldn't even have in me. I almost
I'm gonna
died,
let you
man.
go
I'm
on
not
and try to
gonna be,
get it
I'm
all
not gonna
out.
be under no pressure with no medication. I'm not gonna be taking something that I'm not.
All right, I'll
No.
tell you what I'm gonna do. I've given you 2 warnings. I'm gonna pass the matter. Mr. Allen, you can place him in back. I will decide on what his bond is and everything else. You need to go with my bailiff, sir.
Man, you sitting there. I'm finna
You
get
need
you
to
in trouble.
go with
Okay.
them. Call
I'm a-
security, call security down.
Courtroom the same way, but- Man, you escort the same way. You a part of something that did something to me, man. all the time.
You guys might want to go check back there. I don't know what's gonna happen. Okay.
That's his back.
What?
Backpack.
What about his backpack?
I don't know.
Oh, it's your backpack? Oh, I was like,
You can take it home with you. I'm not, well, they'll get it.
yeah.
Just leave it there. I am not worried about that backpack.
Should be.
I'll pass this matter and we'll come back to it,
Thank you.
maybe.
So make it.
Court calls case people versus Justin Duffany.
Victoria Burton Harris, Assistant Prosecutor of Capital People.
Kyle Burrell on behalf of Mr. Duffany, who's approaching the podium as we speak. Mr. Duffany, please introduce yourself to the court. Thank you, Judge. Today's the date and time set for probable cause conference. I was just appointed on this matter yesterday afternoon. So we are asking for a brief adjournment for discovery and for plea negotiations. At this time, there's also a bond violation or a.
There is.
Yes, Judge. So I spoke to Mr. Duffany. He went to community corrections yesterday at 4:20 p.m., but he did not have the money to test, so he was unable to. We did discuss today. He's going to go immediately to community corrections after this. I do have an email from community corrections to confirm that he was there.
Is he going to test clean?
I believe so, Judge. Yes. He's on what?
Are you going to test clean?
I'm on Suboxone. I'm prescribed Suboxone.
You're prescribed it? I'll pass it. He needs to get over there and test and then come back.
So thank you, Judge.
I'm not doing that anymore. Takes too long. Just go on. Okay. Court recalls the case people versus Justin Duffany. Yeah.
Good afternoon again, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor appearing on behalf of the people.
Kyle Burrell back on the record with Mr. Duffany. Justin, please state your name for the record.
Justin Duffany.
I've seen the results, Judge, and I have gone over them with Mr. Duffany.
He doesn't have a prescription for cocaine, Mr. Allen.
I would assume no. Gonna be all right. Gonna be all right.
All right, I'm going to adjourn the probable cause conference to August 14th, 2025, 9 a.m. His bond at this time, given the violation, his bond is revoked. Defendant's remand.
Thank you, Judge.
I know, but I don't know if anyone, I don't know why I passed them.
Across these hearings, the pattern is consistent. Identity arguments, procedural misunderstandings, and resistance to legal structure. The sovereign citizen language, agent, natural person, not bound by legal fiction, isn't just unusual phrasing. It reflects a deeper belief that the legal system operates on optional consent. But courts don't function on belief, they function on jurisdiction and record. In the first case, the defendant tries to separate himself from his legal name. The judge immediately closes that gap. That decision matters, because once the court establishes identity, every argument built on avoiding it collapses. Then comes the critical fork: representation. The judge clearly outlines the risk. Missed procedures, self-inflicted errors, and strategic blind spots. Choosing to proceed pro se isn't just a preference. It removes the only buffer between misunderstanding and consequence. In the second case, escalation replaces strategy. When the defendant resists a competency evaluation, the court doesn't debate, it orders. That moment shows the limit of defiance. Refusal doesn't stop the process, it just shifts control entirely to the court. And in the final case, the issue isn't ideology, it's compliance. A failed drug test doesn't invite argument. It triggers an automatic consequence. Bond revoked. Different defendants, different approaches, same outcome pattern. When someone treats the legal system like something to out-argue instead of navigate, every decision increases exposure. Not because the court is reacting emotionally, but because the structure is designed to move forward with or without cooperation. And once that momentum starts, it rarely slows down.